Okay. This was submitted into evidence in this case number up here, federal, and it was admitted on March 1st as an exhibit for my habeas corpus petition. You'll see that later. Now, this part here was done after. So she predated it to February 2nd, right, of 2006. So they actually arrested me on this in 2008, June 7th of 2008. But you'll see where they did the conspiracy, right? Melissa Larson, she impersonates a judicial officer and does magistrate. And then she presents herself to me personally as a magistrate judge and obtains a guilty plea to this passing checks against insufficient funds, a $30 check, shortly after the arrest and within the next few days. So they didn't give me a lawyer for that. They didn't tell me my Miranda rights. And she coerced, obtained a false confession to this, saying I would get time served for the time sat in jail, a couple days. Okay. Factors considered in determining arrest. As a result of this unlawful seizure, they found other evidence that resulted in additional charges. All right. Factors considered in determining conditions of release imposed. In determining which conditions of release will reasonably assure appearance. So now, mind you, I was never served with this warrant. I was never served a summons. I was never told I had a notice to appear. So I don't know when I failed to appear that they're claiming that there was a warrant for failure to appear at court on this. There's no case number. There's no judge's signature. It's just the clerk of court signature. And then this date here, this June 18th, that's when I think between June 7th and June 18th is when she fabricated this warrant after the arrest. And then start sending it to places. Take into account the nature. Magistrate or court shall. A committing magistrate or court shall, on the basis of available information of the offense charged, the weight of the evidence against the defendant's family ties, employment, financial resources, character, and mental condition. The results of any mental health assessments, length of defendant's residence in the community. I wasn't even from this community. Additional conditions of release imposed when necessary to assure appearance for trial. Place the defendant in the custody of a designated person or organization agreeing to supervise him. Place restrictions on travel. Require the defendant complete mental health assessment. Require an appearance bond. Require the execution of a bail bond. Impose any other condition reasonably necessary to assure the defendant's appearance as required, including a condition requiring that the defendant return to custody after specified hours. That's for work release. Any escape by a prisoner constitutes second degree. Return to custody after specified hours, not days. South Dakota codified law. All right, second degree escape. An escape by a prisoner constitutes second degree escape if the prisoner effects the escape by means of failure to return to custody following an assignment or temporary leave granted for a specific purpose or limited period, or leaves a non-secure correctional facility without authorization. Second degree escape is a class 5 felony. Order stating conditions of release. Advice to defendant as to results of a violation. A committing magistrate or court authorizing the release of a defendant shall issue an appropriate order containing a statement of the conditions imposed, if any, shall inform the defendant of the penalties for a violation of the conditions of his release, and shall advise him that a warrant for his arrest will be issued immediately upon any such violation. State of South Dakota, bond specifying methods, and I signed this. The highlighted part. I understand that if I violate any condition of my release, a warrant for my arrest will be issued immediately. After arrest, the terms and conditions of any further release will be redetermined. If I fail to appear before the court as required, an additional charge of failure to appear may be instituted against me. Failure to appear. Order reducing bond. Stephen R. Jensen signing this. 10,000. Reduction of bond, Michael J. McGill. that the defendant shall wear a drug patch and comply with all regulation and requirements imposed by the Union County, South Dakota Sheriff's Office with respect to making personal appearances at the Sheriff's Office. If I fail to appear before the court as required, an additional charge. A failure to appear. Make personal appearances at the Sheriff's Office on a weekly basis to monitor the drug patch program. See, I wasn't complying. I didn't want to be I didn't sign up to be no informant. And I sure in the fuck wasn't getting paid for it. I took that drug patch off. It violates my Fifth Amendment right against self-incrimination. Gets work release? Nope. Release reason, bonded out. All right. On 10th of July, I'm already arrested in Sioux City now again. On the 7th of July, I got arrested in Sioux City, Iowa. So 3 days after my arrest, Jerry Miller in that he did escape by means of failure to return to custody following an assignment or temporary leave granted for a specific purpose or limited period. The defendant failed to return to the Union County Jail as directed by his bond for his weekly drug patch check, and for that reason is guilty of a Class 5 felony, contrary to statute in such case made and provided against the peace and dignity of the state of South Dakota. Who interfered with my peace? They did. Motion to revoke bond. That the above-named defendant has violated a material term of the bond by failing to appear at a regularly scheduled drug patch appointment. Okay, what does that statute say? If I fail to appear before the court as required, an additional charge of failure to appear. So all they could do was revoke my bond. Under their law, all they could do was revoke my bond and go to trial on the case as it was. But why did they cover it up? They couldn't charge me with another charge. They couldn't even charge me with second failure to appear, let alone this. Michael J. McGill. Remember, the clerk of court is the one who changed the bond from a daytime only warrant to a nighttime warrant. He's lying. He made a false statement right here. She didn't modify it. She issued the entire warrant and then backtracked on it and said, well, I orally modified it. So this is where they're conspiring, see? All right, so the police officer told her on the telephone that Angel told the police officer that he was calling you because he had somebody drive his car. He did not have a driver's license. According to the clerk, they knew this information before I came upon the scene. So when I was on the way, they're already conspiring, like, who's Daniel Gomez? They did a background check on me before I even arrived within 20 minutes, and they conspired that, and then they said what they decided what they could do. They decided what they could do before I even got there. Which was initiate this warrant. So they had already planned and schemed about 1:40 a.m. in the morning over the phone. Michael J. McGill. Okay, so this is the docket history for my petition for writ of habeas corpus. Quorum nobis attachments. I don't have the quorum nobis, the document that had quorum nobis on it, but return of writ, habeas corpus, certificate in service. They've docketed it on 9/29, but I actually sent it in way sooner. So for filing purposes, this was considered filed on the 19th of August. So they waited a whole 30 days. They didn't do the return of the writ. They defaulted. There's no excuse for that, other than that they was conspiring and conniving on what they should do. Contempt and forfeiture by sheriff. Return to writ. Time for filing. Transfer or concealment. Guilty. Imprisonment for specified time. Evidence of guilty or no contendere plea inadmissible after withdrawal. Right there's the evidence. Motion for withdrawal of guilty plea. It's been withdrawn.